Hi everybody, this is Kevin Brooks with BK Solutions in the Farmland Ownership Series, Lesson 3.2, Contracts. Should I have a written contract? Starting with a disclaimer, get that out of the way first. I'm not an attorney, and the information below is for educational use and should not be considered legal advice. On legal matters, it's always prudent to contact your legal advisor. So keep that in mind as we proceed. Many farms have oral leases, oral agreements. And every year I get a number of phone calls asking if an oral lease is okay. After all, they are quite common. At the U of I in Extension, we hadn't done a survey for about 10 years because of budget cuts and such, but a significant number of leases, particularly as you move south in Illinois, were still oral at that time. And oral leases are actually quite legal with some limitations. They don't do a very good job of protecting either contracting party in the lease. I mean, think about it. If you're married, do you always see things eye to eye with your spouse, or a child with their parents? You can imagine two unrelated contracting parties being able to see things eye to eye. Why would they do that more than relatives? Probably not. And sometimes in oral leases we do see bullying going on. So having a clearly written lease is actually a good thing over an oral lease. Again, part of the problem comes from the gentleman agreements. We have a handshake. We don't want to offend the other party, but those days with the high stakes in terms of dollars that we have today have been long gone. Where I see most of the problems arise is when one of the contracting parties becomes incapacitated or dies. Then the heirs are left to sort things out. That's typically when things go sour, particularly where there are multiple heirs. Joint land ownership among family members is not always easy to deal with, and a written contract can help to decrease the opportunities for fighting, for conflict. Below, and what we're going to go over, are several articles written that are related to farm leases, and they are posted to the FarmDoc website. You can do a search within the FarmDoc website to find these articles. Article number 1, Agricultural Law and Taxation Briefs, Department of Agriculture and Consumer Economics, University of Illinois at Urbana-Champaign. Should farm leases be written? And is an Illinois farm tenant protected if the lease is oral? It's written by Don Uchtman, who did the article we did last week, which was on how to terminate your lease. The synopsis from Don: as a practical matter, a farm lease generally should be in writing for many reasons. However, a farm tenant in possession of Illinois farmland under an oral lease has some protection under the law because such leases are considered to be from year to year in Illinois. This article discusses why it's generally wise to have a written lease rather than an oral lease, and describes how the law protects the farm tenant even if the lease is not in writing. This article is a part of a law-related educational program for farm families in Illinois, made possible through a gift of the Illinois Bar Association. The assistance from Agricultural Law Section of the Council of Illinois State Bar Association in reviewing and otherwise assisting the preparation of the article has been appreciated by Don, as I paraphrase a little bit there. Should a farm lease be written rather than oral? Yes, there are many reasons why, not just because the attorney can make money off of it. As a general rule, an agricultural lease should be in writing. Reducing the agreement between farm owner and farm operator to a written document brings discipline to the negotiation process and helps the parties focus on key issues related to the lease that need to be resolved, helping the parties realize that when they are in agreement and when they are not in agreement, and preserves the agreement for future reference when memories may have faded. And boy, the older I get, the harder that one gets in terms of memories faded, as I add my own 2 cents into that. A written lease is especially valuable if a dispute later arises between the landowner and tenant. Matters such as clear description of the rented property, the time period covered by the lease, and the amount of rent to be paid, and specific rights and duties of the parties, especially any that differ from customary rights and duties in the community, are usually included in a written lease and preserved for use in resolving future disputes. It's in writing. You both signed it. So it's important to have a written lease and to understand what it is that you are signing. Also, under an oral lease, common law and local custom normally control any special agreement, such as an oral agreement that the tenant, upon leaving the property, is entitled to payment for permanent improvements. They're often difficult to prove in an oral lease situation. Another disadvantage is that an oral lease entered into before the tenant is to take possession may be unenforceable. Again, another disadvantage is that an oral lease entered into before the tenant is to take possession may be unenforceable. In other words, if one party decides to back out before the lease actually begins, you're not going to have a lot of legs to stand on if it's I said, they said. Illinois law provides that oral agreements cannot be performed within 1 year of the date of the agreement are unenforceable as a general rule. 1-year lease entered into November 1st to begin the following March cannot be performed within 1 year. Thus, either the landowner or the tenant may have the legal rights to back out of that agreement any time before the tenant takes possession in March 1. And I think I want to highlight that, as those pretty much signify the dates that are often common in a farm lease in Illinois. To encourage landowners and tenants with oral leases to reduce their agreements to writing, blank forms for both crop share and cash leases are available on FarmDoc. That website, as I just noticed, is actually farmdoc.illinois.edu. The landowner and tenant wanting to convert their existing oral lease agreement into a written lease could simply complete the forms by inserting the terms of the oral arrangement into the written lease form, sign 2 copies of the written lease, and give 1 signed copy to the owner, the other one to the tenant. This step at least gives the parties a written record of their existing oral arrangement, bringing both parties the advantage of a written lease. The leases are good. We have a lot of attorneys that use those. I say we because I used to work for the University of Illinois, but a lot of attorneys use those. I will say they are a bit cumbersome, and they tend to be all-inclusive, so you might have to take out some parts of it. We're going to be going over that in a future lesson in quite a bit of detail on how you can use that or other leases that are available online, lease forms. Parties to a farm lease also should realize that a lease creates both legal rights and obligations, and assist legal counsel, and that may be very helpful. When one or both parties seeks legal counsel, the lease forms on the FarmDoc website may serve as a starting point for the lease. These form provisions may be substantially modified as the lease is tailored to meet the needs of the landowner or tenant. Article number 2, written by William Harriman, who actually left the University of Illinois Extension probably about 15 years ago, maybe not quite that long. He was actually gone before I started, and I was with U of I Extension for almost 12 years. But the article's good. 2/3 to 3/4 of central Illinois farmland is rented. In other parts of the state, about half the farmland is rented. The rest is owner-operated. The trend towards leasing farmland versus buying is increasing. As a result, both the farm owners and farm operators need to understand farm leasing, and our surveys up until 10 years ago pretty much signified that trend had continued. For years, farmers have paid a share of the crop for the use of their farmland. It was done through the crop share farm lease. Currently, an increasing percentage of farm operators are paying cash for the use of the farmland, in addition to leasing machinery or farm buildings. Many modern farm businesses control millions of dollars of assets. 1,000 acres of 10,000 acres, well, it's a lot more than 2 million. That would be $10 million, as I updated that. These assets may be borrowed. Tractors are expensive, combines, rented, leased, and the farm ground, the same thing, or a mix of the three. Agriculture is a big business, is what we're trying to point out here, involving millions and millions of dollars, and it's not getting any smaller, and it won't get any smaller anytime soon. Too much money is involved to be left to the whim of the spoken word in other words, the gentleman's agreement. To further complicate the leasing issue, important items such as government farm programs, droughts, record yields, changes to IRS rules, and a new emphasis on pollution-related litigation and strict water quality rules have recently increased the need for these lease negotiations. A written lease provides the chance to address these issues and provide the opportunity to make necessary adjustments. But both parties often still want things done their way, and a well-constructed lease will help to protect both parties. Written versus oral leases. Next. Same article by Bill. Would you trust someone with $800,000 or more of your money to invest, use, and pay you an unknown amount for the use of these dollars? Or pay you at an unspecified time in an unspecified manner? With an oral farm lease, you are doing exactly that. It's a lot of money to be putting on the table to not have a concise outline on how the contracts to be performed. Many of these leases are simple oral agreements, and most of these leases, most of the people feel secure. And quite frankly, they feel unjustly secure. The details of management are either spelled out by the laws of Illinois or assumed to be conventional practice. Without some agreement, oral leases do not adapt well to changing technology. There are many complex issues and many special lease terms to fit your particular farm. Unless these special terms are spelled out in writing, they may not be defensible in court, something that would be important to you given the amount of dollars that are now involved. Think about what's happened to cash leases in just the last 4 years. The written lease protects both parties. If the court of law cannot verify your leasing agreement, then the ruling may change your lease to practices customary in the area, such as maybe it's not no-till and you wanted no-till, maybe it's not organic and you wanted organic, maybe you wanted the soil conserved and the farmer doesn't, and so on and so forth. Trust and communication. The key to having a successful landowner-operator relationship is a careful selection of an operator. I can't stress that enough. Owner and operator need to be compatible, have similar goals, and be able to tolerate each other's weaknesses. It's not unlike taking a spouse. With the average farm tenure of about 18 years, many operators farming the same farm for 30 or 40 years, many landowner relationships with their operators last longer than some marriages in this day and age. One professional manager stated in a written article that he watches a farm operation for several years even before considering the person as a prospective operator. If the owner and operator cannot establish personal trust, then no amount of written words can. A successful lease arrangement begins with the owner and operator working together. Ruth Hamilton, my former counterpart before she retired, put together this checklist that I like to use. Do you have a written lease with your landowner? You should have. Do you and your landowner review your lease once a year? Yes, you should, and if you're not, you really should. Do you contact your landowner to see how things are going? Something else you should do, and if you feel like you're going to upset them, then you probably have the wrong person. Does your landowner check fields with you? Is your landowner related to you? Is your landowner supply you with soil tests? Does the landowner allow you to try new things? Do you feel comfortable with talking to your landowner? And does your landowner let you decide which crops to plant? Those are things from the tenant perspective. And does your farm landowner know enough about business into farming? And that's going to get further and further removed as people are further and further removed from the farm operation. Questions for landowners. Do you have a written lease with your operator? Do you review it at least once a year? You should. Do you contact your operator to see how things are going? And does your operator contact you to offer a tour of the fields? I think that's important, especially if you let them know that you want that. Have you seen recent soil tests? You should. Does your operator clearly explain things when you ask questions? Do you feel comfortable talking to your operator? Does your operator report crops to the FSA for you? And are you satisfied the operator's farming is good as what you could do? Carefully consider your relationship with your tenant. Go over these things. Most disagreements come from contention from one of the above points in the checklist. If things aren't going to your specifications, you may have the wrong tenant. You need to take a look at your contract. Oral leases don't do a very good job of being able to protect the rights of both parties. Suggested lesson, go through your contract. If you're not satisfied with the contract or the questions in the checklist that you got from your farmer, it might be time to consider following the guidelines for termination. Again, we're at the end of 15 minutes. If you have any questions, give me a call. Thank you and goodbye.